Okay. Statute of frauds, writings, and exceptions. The rule: a statute of frauds writings must identify the parties, the subject matter, and it must be signed by both parties to be charged. The statute of frauds rule is that the statute of frauds writings must identify the parties, the subject matter of the writing, and it must be signed by the parties to be charged. Exceptions include part performance, full performance, specially manufactured goods, judicial admission, and the main purpose rule. Those are the exceptions to the statute of frauds writings. So where a writing does not need to be signed, or it does not need to identify the parties, or it does not need to have a subject matter stated, would include situations where there is part performance, where there is full performance, where there is a specially manufactured good, like a unique good, and where there is judicial admission. That means the courts have recognized and that the thing is in existence. And finally, the main purpose rule, where the main purpose of the contract is stated in the writing. So remember, part performance and admissions can remove the statute of frauds. Part performance and admissions would remove the statute of frauds. Remember, when we talk of admissions, it's judicial admissions. Now let's look at conditions. A condition is an event that must occur before a contractual duty arises. A condition is an event that must occur before a contractual duty arises. So if if a condition is available, it must be met. It must occur for that duty to arise. If there's a condition and the condition is not met, then the duty will not arise. Express conditions require strict compliance. So remember, express condition requires strict compliance. Let's look at substantial performance. Substantial performance occurs when a party performs in good faith with only minor defects. A substantial performance occurs when a party performs in good faith with only minor defects. Substantial performance occurs when a party performs in good faith with only minor defects. So remember, substantial performance prevents forfeiture but allows damages for defects. Substantial performance prevents forfeiture but allows damages for defects. Prevents forfeiture, so you cannot forfeiture the terms of the contract or the duty, or you cannot forfeiture your rights, but you can recover for minor you can recover for damages. So remember, It allows for damages for defects. And then, just as to reiterate, substantial performance allows recovery minus damages. If there's recovery, then it will take out damages. Material breach. A material breach excuses the non-breaching party's duty to perform. The rule is a material breach excuses the non-breaching party's duty to perform. Courts consider the extent of benefits deprived. 1. Ability to compensate. 2. Forfeiture. 3. Likelihood of cure. 4. And good faith when looking at the effects of material breach. Again, the rule is a material breach excuses a non-breaching party from performance. And before they are excused, courts will look at the extent of the benefit that was deprived, the ability to compensate that non-breaching party, forfeiture, what was given up, and then the likelihood of cure, if they can be recovered or cured, and good faith. The court will look at good faith, if it was done in good faith or not. Next, anticipatory repudiation. Anticipatory repudiation occurs when a party makes an unequivocal refusal to perform before performance is due. Anticipatory repudiation occurs when a party makes an unequivocal refusal to perform before performance is due. So remember, it is an unequivocal refusal, and that refusal equals to breach. The non-breaching party may treat the contract as breach and seek remedies immediately. So relief available to the non-breaching party if there's an anticipatory repudiation is that they can seek damages, they can seek remedies immediately. They can treat that anticipatory repudiation as a breach and seek damages immediately. Adequate assurances. When there are reasonable grounds for security, a party may demand adequate assurances of performance. If there is reasonable grounds for insecurity, so there is reasonable grounds for insecurity, a party may demand adequate assurance of performance. Failure to provide adequate assurance may constitute repudiation. The failure to provide adequate assurance would constitute repudiation. And remember, repudiation equals to breach, and the party can demand for remedies immediately, can seek for remedies immediately. So again, no assurances may equal breach. If a party demands for assurance and there is no assurance, then it is regarded as repudiation. Repudiation is equals to breach, and the parties can seek remedies immediately. Impossibility and impracticability. Performance is excused when it becomes objectively impossible due to unforeseen events. That's impossibility. Performance is excused when it becomes objectively impossible due to unforeseen circumstances or unforeseen events. Performance may also be excused if it becomes commercially impracticable due to extreme difficulty or expense. Performance may also be excused when it becomes commercially impracticable due to extreme difficulty or expense. That is the doctrine of impracticability. Impossibility and impracticability excuse performance. Now, let's look at frustration of purpose. Performance is excused when an unforeseen event substantially frustrates the principal purpose of the contract. Performance is excused when an unforeseen event substantially frustrates the principal purpose of the contract. An unforeseen event substantially frustrates the principal purpose of the contract. Performance will be excused. Both parties must have known the purpose of formation. For frustration to take place, both parties must have known the purpose of formation, so that if the principal purpose of the contract is substantially frustrated, both parties were aware of the principal purpose. Frustration discharges duties. When frustration occurs, then performance is not required. Let's look at third-party beneficiary. A third-party beneficiary may enforce a contract if they are an intended beneficiary. A third person can enforce a contract if they are an intended beneficiary. Intended beneficiary keyword. Rights vest when the beneficiary assents, relies on the contract, or brings a legal action on the contract. So the rights of a third party would vest when the beneficiary sue under the contract, or they rely on the on terms of the contract, or they accept to take over the terms of the contract. Only intended beneficiaries have rights. A beneficiary that was not intended cannot claim rights. Those rights have to be vested to the intended beneficiary. Assignment and delegation. Assignment transfers rights, while delegation transfers duties. The assigner or the delegator generally remains liable unless there is a novation. An assigner or a delegator, they will remain liable unless there is a novation. Rights are assigned, duties are delegated. So both assigner and delegator will remain liable. They will stay in the picture unless they have a novation. A novation makes them disappear from the picture. of the contract. Now let's look at liquidated damages. Liquidated damages are enforceable if damages were difficult to estimate and the amount is a reasonable forecast. Liquidated damages are enforceable if damages were difficult to estimate and the damages and the amount of the damages are a reasonable forecast. So liquidated damages can be enforced if the damages were difficult to estimate. So if the damages were difficult to estimate and the amount was a reasonable forecast, then liquidated damages will be enforced. So two things have to happen. The damages were difficult to estimate at the time of the contract, and that difficulty of estimation was reasonably forecasted. So the amount that was difficult to estimate was forecasted, reasonably forecasted at the beginning of the contract. That's where liquidated damages will be enforced. A penalty is unenforceable. So a party cannot include a penalty in their contracts as a liquidated damage. It's not enforceable. Reasonable forecast is not a penalty. Reasonable forecast, there must be reasonable forecast. So the damages must be reasonably forecast and you cannot include a penalty. Okay. Now let's look at restitution, unjust enrichment. Restitution prevents unjust enrichment by restoring benefits conferred. Restitution prevents unjust enrichment by restoring the benefits that were conferred. Restitution is available when a contract is unenforceable or rescinded. So when a contract is unenforceable, then restitution will be available. When a contract is rescinded, then the restitution will be available. Restitution restores benefits. So let's move to another section. UCC buyer remedies. What are the remedies that are available to a UCC buyer? 1. A buyer may cover. 2. A buyer may recover market damages. 3. A buyer may seek specific performance for a unique good. He may recover for market damages. He may cover the price or whatever the damage was, and the buyer may also receive incidental or consequential damages. The buyer also can seek specific performance. So I think there are 4 actually. 4. Let's name them again. The buyer can sue to cover the damage that had occurred. 1. The buyer may recover market damages. The buyer can sue to recover the market damages that has occurred. 2. 3. The buyer may seek specific performance if it is a unique good. And 4. The buyer may seek incidental and consequential damages. The buyer may seek incidental and consequential damages. So you might recover for market damages, receive specific performance, cover incidental and consequential damages. So let's look at UCC seller. So that was a UCC buyer. Now what happens to the UCC seller? The UCC seller may recover goods and recover resale damages. The UCC seller may resell goods and recover resale damages. One, or they can recover market damages. So what is available for them, for the seller, is to resell the goods and recover market damages, or can recover resale damages, or market damages. A loss volume seller may recover lost profits. Sellers may recover resale damages, market damages, or profit damages. Those are the things that the seller can recover: resale damages, market damages, and resale damages. Profit damages, market damages, and resale damages. Meanwhile, the buyer would recover the cover price, the market price, the market damages, the specific performance, or recover for consequential and incidental damages. Now let's look at capacity. So things like capacity are highly tested in the exam. Capacity, the rule is capacity must have, a person must have capacity to contract. A person must have capacity to contract. Contracts with minors are avoidable at the minor's option, except for necessities. Contracts entered into by a mentally incapacitated or intoxicated person are avoidable if they could not understand the transaction. Lack of capacity makes a contract voidable. Let's look at misrepresentation and fraud. A contract is voidable if assent was induced by fraudulent or material misrepresentation. A contract is voidable if assent was induced by fraudulent or material misrepresentation. Fraud requires a false statement of fact, intent to induce reliance, actual reliance, and damages. So the elements for fraud are: there should be a false statement, one, false statement of fact, that's one. Intent to induce reliance, that's two. Actual reliance, that's three. And damages occurred. Fraudulent misrepresentation makes a contract voidable. Always remember, fraudulent misrepresentation makes a contract voidable. let's remember the elements of misrepresentation once again. There should be a fraud statement, a false statement of facts, intent to induce reliance, actual reliance occurred, and damages occurred. So there are four elements for fraud. Okay. And also remember that a fraudulent misrepresentation makes a contract voidable. Now let's look at duress and undue influence. A contract is voidable if entered into under duress caused by an improper threat, leaving no reasonable alternative. That's the rule for duress and undue influence. A contract is voidable if entered into under duress caused by an improper threat, leaving no reasonable alternative. A contract is voidable, just like fraudulent misrepresentation is voidable. When a contract is entered into under duress caused by an improper threat, leaving no reasonable alternative, then the contract becomes voidable. A contract is voidable if entered into under duress caused by an improper threat, leaving no reasonable alternative. Undue influence involves unfair persecution of a vulnerable party by one in a position of dominance. Undue influence keyword involves unfair persecution. That's the keyword. Unfair persecution of a vulnerable party by one in a position of dominance. Duress and undue influence make a contract voidable. Now let's remember what undue influence is. Undue influence involves unfair persecution of a vulnerable party by one in a position of dominance. Undue influence involves unfair persecution by a vulnerable party by one in a position of dominance. Undue influence is voidable, makes a contract voidable. And then duress makes a contract voidable if entered into under duress caused by an improper threat, leaving no reasonable alternative. Improper threat, leaving no reasonable alternative. Unconscionability. The court may refuse to enforce a contract that is unconscionable. When a contract is unconscionable, the court will refuse to enforce that contract. Unconscionability requires procedural unfairness, substantive unfairness. Unconscionability requires procedural unfairness and substantive unfairness. So a court will refuse to enforce a contract if the contract is unconscionable. Unconscionability involves procedural and substantive unfairness. Substantive unfairness. Unconscionability makes a contract, the court not to enforce a contract. Unconscionability makes a court not to enforce a contract. So let's look at mistake. Mistake, the rule for mistake is a contract is voidable for mistake, or a contract is voidable for mutual mistake if both parties are mistaken as to the basic assumptions with a material effect. So a contract is voidable for mutual mistake if both parties are mistaken as to a basic assumption with a material effect. If both parties are mistaken as to a material assumption or a basic assumption of material effects. Okay, so there is a mutual mistake. Mutual mistake involves both parties, and there's unilateral mistake. Unilateral mistake generally does not excuse performance unless the other party knew or should have known. So mutual mistake involves the mistake where both parties make assumption as to a material fact of this contract. And then unilateral mistake involves the one party who knew or should have known of a fact, and the other person is in the dark. So it involves just one person. That's unilateral mistake. Unilateral mistake generally does not excuse performance. So because there was a unilateral mistake, a party cannot say they will not perform. There must be performance unless the party knew or should have known. If the party knew or should have known, that then it's no longer a mistake. It's more like a false statement or misrepresentation, and then it becomes voidable. The other party will be excused. So you need just remember that mutual mistake may void a contract. When it's two people, the contract is void. When it's one person, the contract still stands unless the other party knew or should have known of the mistake. Okay, let's look at illegality. Contracts for an illegal purpose are unenforceable. Contracts for an illegal purpose are unenforceable. Court may allow restitution to prevent unjust enrichment when justice requires. So the courts would allow restitution to prevent unjust enrichment when justice requires. Remember, we saw earlier that restitution was the courts conferring returning a benefit that was conferred. So in this case, of illegal purpose, a court may allow restitution to prevent unjust enrichment. So the court might, if it's, say, the car was stolen and the other party did not know that this car was stolen or the sale of the car was illegal, then the courts will encourage restitution, return the money for the buyer, so to prevent unjust enrichment when justice requires. Illegal contracts are unenforceable. Now let's look at parole evidence. This is an add-on because we've seen parole evidence earlier. Remember, the rule for parole evidence was that extrinsic, when an expression of a writing is final, the courts will not allow extrinsic or contemporaneous activities or writings to be introduced. That was the main rule for parole evidence. Now, the exception, we want to add what are the exceptions. When would the parole evidence be admitted, like extrinsic or contemporaneous evidence? When can they be admitted? One, they can be admitted when there is fraud. Two, they can be admitted to show a mistake. Three, they can be admitted to show duress. Remember, we saw earlier that duress is when someone entered into a contract caused by an improper threat, leaving no reasonable alternative, right? So when there is duress, then they can a party can seek parole evidence to show that they entered into the contract with no alternative from a dominant party, Then also condition. A condition precedent, the parole evidence can be introduced to show a condition precedent. So there are 1, 2, 3, 4. There are 4 reasons or exceptions where a parole evidence will be admitted to a contract. So when a term of a contract is final in its expression, the parties cannot introduce extrinsic or contemporaneous writings unless it is to show fraud, to show mistake, to show duress, or to show a condition precedent. It may also be used to explain ambiguities, but not to contradict a final writing. So parole evidence could also be used to explain ambiguity, but not to contradict a final writing. So parole evidence have exceptions. What are the exceptions? 1, for duress, to show that there was duress. 2, to show that there was fraud. 3, to show that there was mistake. 4, to show that there was a condition precedent. And 5, to show that to explain an ambiguous statement. But this ambiguous statement explanation is not to contradict the final writing. Whenever the expression of the writing is final, it is not to be allowed extrinsic or contemporaneous evidence. But such an evidence can only come in to explain if there's ambiguity. Okay, now let's look at implied